It is Tuesday, May 21st, 2019, and it's 8:30 p.m. Central Standard Time. Welcome to week three of Introduction to Criminal Law, and I'm Professor Richard Wright, and you should be aware of the fact that the quarter is moving on pretty fast, and that before you know it, the quarter will be over. So I'm going to go ahead and get started right away with my lecture here by sharing my screen. Okay, as you can see, let me move this up. As you can see, the information on the first page, and remind you that the critical thinking video is still available. If you want to check on critical thinking, copy and paste this. Remind you that rubrics are included in each written assignment, and then your discussion post, you should be familiar with the rubric. You can see that week three, and after that we have three more lectures to go. At the end of tonight, I will include week 3 lecture under the recording. Now, one of the things that I want to say is that as we head towards the second half, which the second half of the course actually begins next week, that any assignments from weeks 1, 2, and 3 that are not submitted according to arrangements that I previously made or not submitted will not be allowed, because of the fact that we will be in the second half of the course. And it's very important. I always remind students that with these 5.5 courses that it is important that you keep up. This course will be over in 3 weeks. Matter of fact, it'll be 3 weeks from today that the course ends. You'll see when we get to the course calendar. So now let's take a look at our announcement. I encourage students to look at the announcements all the time. So today we're going to talk about crimes against persons. All right. Last week we talked about crimes against property. And so to prepare for this, you're going to read chapters 4, 5, and 6, which I provided to you previously, the PowerPoints, and make sure you read those so that you can be prepared for the quiz. And then read the chapters. And then the activities: homicide, battery, domestic violence, sexual assault crimes, and then you know how the key terms operate for practice, and special circumstances and homicide classifications, then the practice quiz. And then your discussion assignment, which is due tonight, your initial post: what type of homicide is this? Again, your initial post is due tonight. Reply post is due Saturday, 11:59 p.m. Central Standard Time. And then for Sunday, coming up, spousal rape, the written assignment, which I will again discuss in a few minutes, and then the quiz. Remember, the quiz is timed, okay? Adversity is the springboard to success. You know what that is all about, because I covered that during week 1. Now let's look at the course calendar so that you can see in the calendar, which you all should be familiar with now, and you see where we are. We started up here. Now we're down here. This is week 3. And then if you click on it, again, it tells you the same stuff that I already covered. It tells you about your initial post, and it tells you about the lecture when it takes place, and then your reply post, and then your quiz, and then written assignment that I shared with you. Okay, and notice that there are 3 check marks which remind you of the due dates for all 3: the written assignment, the quiz, and for the keyword or phrase that takes place in this lecture. And you can see as we go down, let's take a look at where we are here. And you see that in June, so like next week, which will be the 28th, we'll have 3 more weeks left. The course actually ends on the 14th. The 14th is when the course ends. Not the 16th, but on the 14th. So you need to be aware of that as well. Okay? So you have all the details as far as the way the class operates. So now let's close this up, close the calendar, and let's go to the module itself. Let's take a look at the assignments. Again, the discussion post, you use this fact pattern, and then you answer the following questions in your initial post, and then your reply post. Remember, I encourage you to reply to more than one post. Citations are appreciated, but not required. And remember, you still have help tools here and guides that helps you not just with the discussion post, but also with the actual written assignments as well. And so now let's take a look at your written assignment. Now, this is a 2-part. You don't have a choice, and you need to make sure you read this very carefully. And it talks about the various crimes. You'll apply sexual assault laws to the scenario, and then consider what type of interview questions you would ask the individual. Now, make sure it is very important that in part 1 that you cover each of these issues. Notice it is a minimum of 2 pages, not counting the reference page. There should be citations in the body and references at the end. And then your interview, make sure you have questions that cover at least a minimum of 1 page. A minimum of 1 page. That means that you should have several questions, and then what you'll do is you'll explain how you'd approach the interview, and then what sensitive questions that you will provide at the same time. And that's very, 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 very important, okay? So you want to make sure that you have that information there. So now that you've got that, let's go look at the rubric. Remember, the rubric is so important. I remind students, look at what it says in the module, but then click on the rubric. It tells you the due date, and then it provides the same information. List the elements of the offense and explain. Now, don't just do it in a list form. You're going to write it in a narrative form. Explains the type of crimes committed and why the initial responding officer mishandled the case the first time, and 2 pages is required. All right? And then the second part is to conduct the interview. Answer all the questions. A minimum of 1 page for that. And then you need to satisfy these requirements, which are ones every week. And APA is there, and no use of Wikipedia or other generic sources. So that's the assignments for the week that we have here. Now, I'm not done yet because you got 2 other things that are listed as assignments, one of which is the quiz. And I already explained to you the importance of how you should prepare for the quiz. Use the materials that I supplied you to help you prepare. Make sure you've read your chapters, and then listen to the lectures as well. It is a time quiz. Once you start, you can't stop it. And then, of course, your live keyword that I'll give you during the course of this lecture, you're going to provide that to get your points. Remember again that in order to maximize your points, you need to do it by Sunday, 11:59 p.m. Central Standard Time. Each day it decreases. all the way until you get to Thursday when you don't get any points at all. And that's the assignments. Very, very important, though. You got to read very carefully and stop and think about what they're asking for. This is the scenario. By the way, providing the facts of the scenario and putting it in your paper will not satisfy the 2 pages. The 2 pages I'm looking at is your analysis and dealing with the 3 issues that are listed here. All right? When it says list the elements of the offenses explained, don't just give me a 1, 2, 3 down and then you think that's going to be filling your page. That is not. No, 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 no. I don't want that. And then you're going to explain the types of crime. And then be sure to explain why the initial responding officer mishandled the first time. And if you use your textbook, make sure you use other sources. Include a reference page, APA citation as well. And I said this over and over, and it's in your rubric too. All right, and be sure to cite all the sources. And then your interview, you're going to use this scenario down here. Once again, if you need help, we have this guide that helps you with the weekly assignments. There's a library for resources that you can find. Make sure you do APA properly. We have the APA toolkit that is also available in this guide. And then if you need help with tutoring or writing lab, there's information in there that tells you how to get that as well. So having said all of that, now I'm going to go and get into discussing the issues here. So we're going to talk about crimes that are committed against individuals. We're going to deal with homicide, voluntary and involuntary manslaughter, and then justifiable homicide, battery, and then substantial battery, or as we call it, aggravated battery. And then we're going to deal with domestic violence as well. And then we're going to deal with sexual assault issues. All right. So here's what we're going to go through each of these topics. These 1, 2, 3, 4 in the lecture, and then we're going to close out by just showing you some examples of how to practice. So what is homicide? Homicide is just simply stated as it says here, it's killing a person. Now, there's what we call justifiable or lawful, and there is unlawful homicide, but it's still homicide. Utilizing self-defense still results in a homicide because the definition of a homicide is killing of one person by another. So talking about when police use deadly force to prevent bodily harm or death to themselves or other, homicide is deemed to be lawful or justifiable. And the same thing can happen with individuals in certain situations where we deal with self-defense. We deal with stand your ground in some jurisdictions such as Florida. And so talking about the other side is that, and it talks about when an upset boyfriend intentionally kills his girlfriend because he believes she cheated on him, this killing is still unlawful, but and is referred to as murder. And the reason is because he did it intentionally. The key thing, so the unlawful killing of a person by another. So now let's talk about the different degrees of murder. Now, first of all, first-degree murder is basically these 3 elements: causing the death of another with premeditation or intent to kill that person. We call it malice and aforethought, which means then that individual has decided they want to kill that person. There's no kind of accident. They can have planning involved. But the key thing is that when you plot out to kill someone, it's always going to be what we call first-degree murder or murder. or murder, period, in some jurisdiction. And it says that in this section here, it says that if it was later determined that the killer had told a person of his intent to kill a person and did carry out that action, the statement can be used against that person to justify that they intended to, or they were involved in premeditation. And other times, if a person tells someone, I'm going to kill you, and then fires a gun at that person, then that's murder because it's clear it was intentional versus accidental. So motive could also uncover, such as people being killed in an arson, in a fire. That's murder. Email evidence indicating that a killer planned and intended to kill a victim in an effort to collect insurance money would be used to help support the statements of first-degree murder. So what you see are these three elements. Causing death, number one, so the person has to die, of another human being, has to be a human, and it must be premeditated and intent on that individual. That's it. That's it. All right? But when we say with malice and aforethought, what we're referring to, the fact is that that person had an idea of what they wanted to do, and they did take steps to do so. Now, second-degree murder, on the other hand, sometimes is referred to as manslaughter or voluntary manslaughter, as you see here. See, in these jurisdictions, like in Illinois, we have a second-degree murder, and that the defendant, at the time and the date they did something, they knowingly caused the death of another person. So that means that that individual, it was clear that they were going to kill that individual, but the element of second degree doesn't require premeditation or one's mindset at the time, but they include the intentional killing. So it must be, again, not done by accident. That means they came upon someone and they did something and they killed them. And it was not done with any justifiable basis, so therefore it would be considered second-degree murder. It says second-degree murder, also known as voluntary manslaughter, when the killing is done without prior intent. Remember what I talked about earlier. The more you get to the intent issue, you're going to kick it up to first-degree murder. A heat of passion killing occurs when an ordinary person under similar circumstances experiences an irresistible impulse, or they lose control and they killed another human being. Such as, for example, if a person walked upon someone, a spouse, having sex with another individual, and they took out a gun and shot them, then that would probably fall under second-degree murder because it would be in the heat of passion. So it talks about, notice this, the scenario that they talk about. They say heat of passions are applied to murder cases when the murder happens immediately in the moment that causes the irresistible impulse. It'd be difficult to lessen the severity of murder under this concept. If Bob, for example, came home and found his wife in bed with Jim, but then hunted him down the next day and killed him, that's different, because then there we go with the premeditation. It must be simultaneously with the action or the activity that takes place. So voluntary manslaughter, as Tennessee states, is a good one, is the intentional or knowing killing of another, passion produced by adequate provocation. And so the person acts irrational. So we oftentimes can tell you this, that, for example, in Illinois, first-degree murder does not qualify you for probation or a lighter sentence. But on the other hand, second-degree murder will allow probation to be brought in. But remember, the reason is we're dealing with this heat of passion issue. I had a young lady that I knew years ago, and I might talk about this later, with a domestic violence issue, where she was the victim of many beatings by her husband. And he beat her pretty severely. And then she ended up finding herself in a scenario where she got tired, and she waited for him to go to sleep and then shot and killed him. Now, when she shot and killed him, there had been no beating, or a beating had taken place a while ago. Do you think that she would be possibly found guilty of first-degree or second-degree murder? Which one? Which one do you think? Which one? Yep. And why first-degree murder is involved here is because she plotted and planned it. And that's the thing. Remember, in dealing with second degree, it has to be like simultaneous, instantaneous. Let's say, for example, if he was attacking her, of course, then that would maybe a self-defense issue. But let's say, for example, if, she found herself, in a situation where he was just beat her, and then she picked up a gun that was there and shot and killed him while she was still under the influence of that beating, there's an argument that could be made that it wasn't first-degree murder. But the fact that she waited for him. Now, I say this to you, and when we talk about domestic violence, I'm going to talk about it a little more, is that I believe I could have beat her case and got her off completely with a jury, because of the fact that the jury would sympathize with her being a victim of domestic violence. However, again, the standard that you need to remember to help you as a student is first degree involves premeditation and planning. Second degree involves provocation, but no premeditation. It means that it's a passionate situation or you're operating emotionally. That's pretty much what we're talking about. All right? Let's talk about special circumstances now. Special circumstances homicide deals with a number of things. It says aggravating factors are most often considered in death penalty cases. So that means the heinous aspect of it. Two aggravating factors that apply to the death penalty. Now remember, it has to be in a jurisdiction where there is a death penalty first. Like Illinois doesn't have a death penalty. Wisconsin does not have a death penalty. I don't know about whether Minnesota has a death penalty or not, or Florida, where many of you are located, has it North Dakota? I don't know for sure. But I do know for a fact, Illinois used to have one, but we don't have one anymore. And Wisconsin has not had one as long as I can recall. And so anyway, it deals with the issue of future dangerousness, the probability that the defendant would commit criminal acts that would constitute serious threat to society. These are aggravating issues. And then the kind of outrageous or wanton killing, such as mutilating bodies, such as raping an individual and then killing them, such as maybe killing a child, those kinds of situations. So these are aggravating factors that, as they say, are present in first-degree homicide cases. Then the defendant sentenced to life imprisonment and not death. So, but these aggravating factors have to be present in order to have that person. But if neither of these are present, then the person will get life as opposed to death. Second degree homicide, special circumstances, and you're really not going to have to worry too much about this. Two common circumstances that make up what we call knowing is dealing with adequate provocation. We already kind of talked about that with the situation with Bob. When Bob comes home and finds Jim in bed with his wife, Bob shoots and kills him. Bob would likely be able to argue that he was provocation adequately provoked at the time. So second-degree murder would be an appropriate charge in some states, as we talked about earlier. Coercion. Death was because the actor was forced to do it. For example, Jack is taken hostage, and the hostage taker has a gun to his head. The hostage taker tells Jack, "Shoot Bob or I'll kill you myself." Under such coercion or duress, Jack shoots Bob. So that could be second degree, but then again, it may not be. It depends on the jurisdiction. The key thing is, in the situation that you need to just remember special circumstances, is that coercion or necessity is something that would put it into second degree. Remember, future dangerousness and vileness puts it in first degree murder and could lead to the death penalty. All right? So we're going to skip this part. Then we're going to get to involuntary manslaughter. Now, what is involuntary manslaughter? There is no premeditation, there's no malice, or any of those things, but some actions, such as speeding in a car, such as driving under the influence. And you read these primarily in automobile homicide cases where there is some violation, such as driving under the influence of drugs. The defendant didn't have an intention to kill. His actions or her actions caused the death of another. Then that could be involuntary manslaughter, all right? Or doing something, as we say, speeding and flying through, which means that utter disregard or utter indifference or reckless act could be second degree. But when you get to the point that you just grossly do something on purpose or something like that, then you might find yourself not in involuntary, but in actually first degree. Remember intent, on purpose. The more you can establish the fact that an individual commits an act on purpose, the more you can put them in first degree. All right? That should be pretty clear. So there are different degrees of involuntary manslaughter. And here's a scenario that we talk about in a minute. At 11:30 on a clear but cold January day, and the streets are dry, a 23-year-old male named Jim is drunk. He's operating his vehicle on a residential street at 25 miles an hour. His girlfriend is seated next to him, and they're both drunk, in other words. Jim decides he want to impress her and accelerates to 80 miles an hour. Drives through a stop sign and collides with another vehicle, and the person is killed instantly. So the question is, did Jim demonstrate an utter disregard for human life, or were his actions merely reckless? Here we go back to this. Utter disregard for human life is a course of action that causes deliberate intention to harm, or which, if intentional, if not as intentional, is utter indifference to conscious or disregard persons for their own safety. On the other hand, reckless simply means indifferent to carelessness of the welfare of others. So both of these cases could result in death of another. Proving utter disregard is more challenging when it's shown that the actions that cause death equated to a conscious disregard. Now, so the question here is, did the alcohol negate the recklessness or the utter disregard? Was he in a state of mind where he found himself in a situation where he actually killed this person? So did Jim demonstrate utter disregard for human life? Probably. Or were his actions merely reckless? I would say probably the former. He disregarded human life. But the point of the matter is, he was also indifferent. So there may be a little bit of both. There may be a little bit of both. And you can see why I say that. It depends on how the trier of fact and how the defense portrays Jim at the time. If the defense focuses on the fact that maybe, let's say Jim was an alcoholic and he was intoxicated, and then, you know, him doing this, which is going to be involuntary manslaughter, but the point of the matter is what level? What level will it be? The point of the matter is clear that it is involuntary manslaughter, and whether it's a first degree or a second degree is the issue. All right. Involuntary manslaughter can also occur in battery cases where one punch causes a person to hit their heads or they lose their lives because of a punch. And I'm not talking about boxing now. I'm not talking about that, because there's a Latin phrase that applies in what we call torts law or personal injury law, valenti non fit injuria, which means that if you're in the ring, you expect to be hit. So there are individuals who have had concussions, but they were in the boxing ring. But it's different when you're not. So we're not going to go and look at these clips, but at your own time, you can take a look at it. So you can see here is that these are various things. But remember, if you don't remember anything else, is that the more intent, the more deliberateness, the more you're in first degree. Whenever there's some special circumstances, or either it's out of the heat of passion, or it's not planned, then it could be second degree murder. And actually, second degree murder, and in some jurisdiction, is also called, as you already saw, it's called voluntary manslaughter, okay, as opposed to involuntary. Involuntary manslaughter pretty much involves actions that are either utterly disregard for life, utterly indifferent, or either reckless. Okay. Moving right along, let's talk about battery. Usually when you hear someone talk about battery, they usually refer to it as assault and battery. Now, battery is different from assault. And in most cases, a battery is a misdemeanor, which means, as I've shared before, that a person is generally sentenced for less than a year, and they go to jail as opposed to prison. However, if, and usually there's minor injuries, but if, for example, some weapon or something is used, then it reaches the stage of aggravated battery, and it jumps into a felony. Now let's talk about assault and battery. And in some states, it says here, battery may be referred to as assault, but don't get confused by that. Let's just forget that point here, that Utah is doing it. Here's the general operation. Assault and battery are sometimes synonymous, but there are differences in criminal law, and this is what I want you to focus on. Assault is this. If I raise my hand and you're in fear that I'm going to strike you or hit you, that's an assault. If I pull a gun on you, but I don't fire it, that's an assault. If I pull any kind of weapon, now then that might be aggravated assault. But the point of the matter is, assault is basically where there is no physical contact. And if the contact occurs, then it elevates to battery. Most batteries start with assault before. But if a person for example, comes up behind a person and pushes them or knocks them down, it might be battery and not assault, because the person has to have a reasonable belief that they would be harmed. And so if there is that, then you can have assault and battery, which usually merge into battery. When someone strikes someone against their will unintentionally, and there's physical contact, that's the battery, all right? And so you have to look at each jurisdiction to determine how battery is involved. But this is the key thing that you're going to probably remember for the quiz, is assault doesn't require hitting. It just places that person in apprehension of being struck. The battery is when the contact is actually made. So I raise my hand, and then I do this. As soon as I did this, I committed battery because I made contact with that person. All right? As it says here, intentionally causing bodily harm to another is considered a simple battery according to Wisconsin state law. Bodily harm is any physical injury, illness, or any impairment of physical condition. Evidence of bodily harm is supported by what the victim reports that happened. Photographs, injuries, even medical records can produce those kinds of things. Then we get into intentionally causing great bodily harm or serious bodily harm. Then we get into the term serious bodily harm or great bodily harm, which involves unconsciousness, knocks that person, disfigures that individual. Then we get into generally what we refer to as aggravated battery. Then we deal with mayhem, which is a most serious bodily injury where a person, for example, might pour acid or hot water on a person or something of that nature, or cause the body to be disabled, disfigured, cut them, or something like that, or as it says here, disables the tongue. The bottom line is that that's when mayhem. But we don't use that term very often. We use aggravated battery pretty much. So look at the scenario to see if you consider it as mayhem. 18-year-old girl, Angela, was at a party with a 21-year-old male, and both were drunk. As the night progressed, Angela and Drake participated in a bizarre ritual in honor of a cult-like band that they followed. With Angela's consent and participation, Drake slit her wrists and drank her blood. This is very eerie. Then, to clearly show their commitment to the band, Angela allowed Drake to chop off her pinky finger with a meat cleaver. Absent her right pinky, Angela eventually became lightheaded and was dropped off at a local hospital for treatment, where she told the emergency room doctors what had happened, and they notified the police. So the question is, did Drake commit mayhem against Angela? Again, serious bodily harm. Every person who unlawfully and maliciously deprives a human being of a member of his body, or disables, disfigures, or renders useless, or cuts, or puts out the eye, or any of those things, is guilty of mayhem. Is he guilty of mayhem? Definitely. Definitely. Because it's clearly, I mean, he cut off her pinky finger. It's not about her giving consent. So he still committed mayhem. All right? Very simple, but you won't run across that a whole lot. It, what it does, mayhem, is protects the individual from giving consent. And remember, she was drunk, and they were both drunk anyway. Battery occurs between complete strangers and even among those who love each other. And then they talk about how in our next lecture we'll turn to domestic violence. Well, not in our next lecture. In a few minutes, we're going to turn to domestic violence in terms of dealing with that, which is right now. So what is domestic violence? First of all, I described domestic violence to you very eloquently in week 1 that I lived through. And it generally involves a partner, whether they're married or not, who share the same living space, house, and commit a criminal act. The man committed aggravated battery on my mom. He committed battery on my mom. He eventually killed her, committed murder. But there are serious issues with domestic relationships where domestic violence has its own little area, where generally what happens is that now it is recognized that domestic violence affects the children, which I already shared with you how it affected the loss of my baby sister. But the point of the matter is, there are oftentimes individuals who find themselves around domestic violence as a kid. They grow up and become offenders of domestic violence themselves. Doesn't always happen, as I'm living proof of that. And none of my siblings actually became violent individuals or were ever found guilty or charged with any kind of domestic violence. And remember, they were arrested and were females, and I was the only male. But if batteries happen within the relationship when it's domestic, criminal charge is battery, and domestic violence is enhanced by that offense because it's within the abode or a relationship involving those individuals, and carry penalties above simple battery in itself. All right, and domestic violence varies according to jurisdiction. But state laws, as it says, that in order for domestic violence cases to be prosecuted, the crime occurred within the context of a domestic relationship, as I said earlier. And that could be an intimate partner, someone living together, or have a child in common, and the relationship exists, and then a battery or some other offense takes place as a result of that relationship. And it talks about the various issues that can take place in domestic violence, which I shared with you. Now, from a domestic violence perspective, the definition of a domestic relationship fits the following, as I said: 2 adults at least 18 years old who live or have lived together or have a child in common. Now, let me say this. Domestic violence now is starting to change because people are living together sometimes as early as 16 and 17 years old. And so states like Alaska recognize that, and it says expand the definition of domestic violence to include adults or minors who are current or former spouses who live or have lived together, or who are dating or have dated or engaged in a sexual relationship or have a child in common. That's the trend that is taking place. Let's see, what was the question? Lightning. Oh, okay. Okay. All right. So you're in a storm area. That's what you're saying. Okay. I got you. But anyway, yeah, don't get electrocuted listening to the lecture. It is important that law enforcement officers within each state apply the laws based upon their own jurisdiction. And so there's usually warnings. There's plenty of shelters, not enough, where spouses or significant others are able to go to state. Unfortunately, there are these documents issued called restraining orders, and when I was younger called orders of protection. That's supposed to protect the individual, but I have learned over and over that the paper doesn't matter. It's the mindset of those individuals. And there is a thing called what we call the cycle of abuse, where a partner will do something and then they will apologize. They will try to do something to make up, maybe buy you flowers, candy, or take you out to dinner or something. But I always tell people this: if a person's going to put their hands on you, you need to get away from that person, and that person needs to get some help before you're back together. And I say that based upon my experience in life. I've had a couple of my daughters who have had problems with their spouses, and if they didn't have the physical violence involved, I would tell them, well, you guys need to try to work it out, or maybe we can sit down and talk about it. Sometimes they didn't want to do that because one might, the other person might feel that I would be biased. But anyway, the bottom line is this, is that domestic violence is a very, very serious offense. It results in the death of many, many individuals and the destruction of many, 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 many families. And so you could take time to look at some of these things. I can tell you this, that I cannot tell you in my years of being a lawyer that I was a lawyer who defended a person who was charged with domestic violence. It would be unfair to them, so I never did. I never did. There are also certain instances where they talk about where the batterer is a law enforcement officer. It happens a whole lot. It happens more than you know. And it says, it says, 2 studies have found that at least 40% of police officer families experience domestic violence since 2013. That's a lot. Since carrying a firearm is a necessary part of that, the officer convicted of domestic violence often is terminated and not able to carry their weapon at all. Okay. Sexual assault crimes. This is the last thing that we're going to talk about. Dealing with this at common law, it said the act of unlawful intercourse by a male and a female other than their wife without their consent. But today rape is generally referred to as sexual assault, and it is gender neutral because of the way the world has evolved and changed. The victim may be of either sex and can also include spouses under certain circumstances. Sexual assault, though, doesn't require that intercourse take place, but it also includes unlawful touching of a private area, the genital area of another, or some object used to invade that person's genital or sexual area. And they're very sensitive. A lot of people have a lot of psychological issues. I know people in my family who found themselves being sexually assaulted, and I've talked about that during my lecture during week 1, dealing with some of my siblings, you know. But it's a very serious issue. It says sex crimes are commonly known as sensitive due to their obvious sensitive nature. It's imperative that these investigations are handled with empathy and understanding. Usually in those teams, there generally is a female if there's a female involved. And even if there's a male involved, there might be females involved. And you see the hand up, it says no. No means no, period. And if you violate that, then you could be charged with sexual assault. All right? Look at the different degrees of sexual assault that, for example, that are laid out. States that anybody who engages in sexual penetration with another or in sexual contact with a person under 13 is guilty of criminal sexual assault in the first degree if any of these exist. The victim is under 13 and the defendant is more than 3 years older. The victim 13 to 16 and the actor is more than 4 years older than the victim and in a position of authority, and it goes on down and down and down. The point of the matter is to protect individuals who are young from being taken advantage of. That's the whole point in a nutshell. Second degree is criminal sexual conduct. Prohibits a person from engaging in sexual contact under the same outline as in the first degree. But the point of the matter is that the term sexual contact, intentional touching or fondling of the victim's intimate parts take place there. So here's the point. In Minnesota, second degree prohibits a person from engaging in sexual conduct and contact under the same outline in the first degree. But the point of the matter is, if you read in the first degree, it says, look, it says engages in sexual intercourse or in sexual contact with a person 13 years age or over. So what we start talking about then is a difference in age in terms of dealing with second degree, but it's still sexual conduct problematic. Any of it is bad and can land you in jail. By the way, when you go to jail for most sex offenses, it's not good because most criminals don't like pedophiles and rapists. Third degree, in the third degree, prohibits a person from engaging in sexual penetration with another person if any of the following. The victim is under 13 and the defendant is more than 3 years older than the victim. That's the same as first. The victim is 13 to 15 and is more than 2 years older, but not more than 10 years older than the victim. Or the defendant has a significant relationship, such as a parent, foster parent, teacher, counselor, psychotherapist, member of clergy, something of that line. A lot of the priests found themselves in the Catholic Church in that situation. And then it goes down and starts talking about some other issues here. The fourth degree prohibits a person from engaging in sexual conduct under the same circumstances outlined above as in the third degree. And so the key thing is that you find yourself with the less severe reduces the degree. That's in some jurisdictions. You have to look at each state separately in terms of it. But the younger the person is, together with the older person, the more likely you're going to find yourself in a situation where you're dealing with sexual assault or what we refer to as rape. So finally, statutory rape. Statutory rape is something that we call it a strict liability issue, prohibits sexual intercourse between juveniles under the age of 18 and varies from jurisdiction to jurisdiction. And so it is not a defense, oh, that they looked older or they produced ID or they lied to me. Statutory rape laws, as we say, are strict liability laws. They don't require intent, and the mere act of engaging in the sexual intercourse with a person who can't give consent, even if they lie to you, still will find you guilty of statutory rape. It is never a defense to say a minor consented, because minors can't give consent. And that's pretty much how it works. And the final thing I want to say about rape is that finally, because individuals are hesitant to come and bring these cases, rape shield laws were introduced to protect individuals and to encourage individuals to come forth and report rapes. What it did, it says that their prior sexual relationships or were not admissible in court and cannot be brought up in court. For example, a defendant will likely not be able to introduce the fact that a victim of sexual assault has a reputation for engaging in sexual activity with strangers. Can't bring it up because the rape shield laws. And the reason why that is there is to not draw the presumption that because a person was engaged in sexual acts with somebody else, that yours was not rape. And that's pretty much the point there. That is what that's all about. And so that's pretty much it. I do want to show you again, once again, utilizing these key terms. Again, let's show you how to do this. You open it up and you go into the intentional causing of death of one human by another with premeditation, forethought, malice. We know what they call that. It starts with an M, and it's first-degree murder. Okay, I call it murder, but it's first-degree murder, as we learn here. And then you can go to the next one. To be indifferent or careless to the welfare of other people is reckless. You want to go through these. Factors that increase the severity of the offense, especially at the time of sentencing and death penalty cases, we call them aggravating factors. Pain, injury. Wait a minute, we got to go back. So it's called aggravating factors. All right. And then you go on to the next one. And that's how you do each of those, okay? All right, let's get you back. Let's get rid of this. Let's lower this. Okay. All right. So now, oops, we got to go back to our, okay. I think we lost something here. Yeah, I got to go back to stop sharing. Okay, let's go back to my sharing on my screen. Okay, and then let's go back to, okay, allowing. And so these show the different types of things that you can go through there as well. Okay, let's stop sharing. And then let's go back down to, give me a minute here, let me go back to my, let's go back to this. Okay, let's take that out. Let's take that out. Okay. So now we got to go back to, and give me a minute while I open up this tab here to get back into this. Give me a minute. Let me log back into it. Okay, we are going to go into signing in. Okay, here we go. Back to J150. And let's get back to 3. And the lesson content. Okay. Okay, now we're back. So then you can see down here the key terms, and then you got special circumstances, which we kind of talked about a few minutes ago, and you want to do these little practice things for special circumstances as soon as they can pop up. Should be popping up in a minute here. Here we go. Okay, so then you start your activity, and then, you know, you go over these scenarios, all right? Jane and Phil have been married for 10 years and have 2 children together. Jane also has a drinking problem. Jane came home drunk and argued with Phil. Phil threatened to leave Jane and take the children if she didn't get help. Enraged, Jane shot Phil and fled the house with their children. What circumstances would likely be claimed in this case? Future dangerousness, vileness, coercion, or adequate provocation. Let's try adequate provocation. And let's see what it says. That is exactly right. Adequate provocation would likely be claimed because she was so upset at the time. Remember what I told you, that heat of passion issue there. All right. So we go back, and you can go through each of those, and then moving right along. Homicide classifications. You can go through the same thing for practice. And we're about at the end of this. Here we go. Okay, homicide classifications. Frank has a long-standing hatred for Kim. Frank purchased a handgun and hid behind the bushes outside Kim's apartment. When Kim exited, Frank shot and killed her. What homicide classification best describes this? This is it, because it was premeditation and planning. Yep, he laid in wait. So those are the kinds of things. This last one we do. John is a gang member who's involved in an ongoing battle for drug sales, turfed. John tells his other gang members that he's going to kill Jose, a rival gang member. John leaves armed with a handgun and kills and shoots Jose. What classification? First-degree murder. Yep, because his intent was demonstrated by what he said. And then the last thing I'm going to do here, as I scroll down here, is the practice quiz. And I can't tell you how much this will help you to get ready for the actual quiz. And you do this. The intent to cause death with premeditation. Premeditation is caused what type of murder? Second, felony murder, involuntary manslaughter, or first-degree murder. That's right. Intent and premeditation. Remember, we talked about that. Then the last one I'll do is this. Father comes home to find his daughter's 17-year-old boyfriend, of whom he doesn't approve, about to have consensual intercourse with his 17-year-old daughter. Outraged, out of control, the father kills the boyfriend. The father is likely to claim adequate provocation, unnecessary defensive force, involuntary manslaughter, or coercion. He might use adequate provocation or involuntary manslaughter, but let's see what his claim would be. Adequate provocation, because of the situation and circumstance that exists. And so those are the things that you can look to in terms of dealing with. Oops, you probably couldn't even see that. I forgot. You couldn't see them because I didn't share my screen. I'm sorry. Let me go back. I'm gonna do it one more time. I'm gonna share my screen. That was my bad. Again, I want to go back down and show you what I was looking at. I was looking at these key terms, and then you click on them, and then I used the flashcards. Then I did this to get them operating and working. And then you do this and then flip the card over. All right. And then let's go back to that. let's get rid of, let's move my picture there. Let's move this. Why I can't move it? Here we go. And then we come down here. You can now see it. Special circumstances. And you go click on that. And then it opens and starts the activity. Okay. So then I talked about this Phil and Jane, special circumstances. She would probably use adequate provocation, and that's what I said would be the correct answer. Okay? So you could do those as well. Scrolling back down again. You have the homicide classification. You can do the same thing. Go through and the activity. Frank has a long standing hatred for Kim. He purchased a handgun, hid behind the bushes outside Kim's apartment. When Kim exited, he shot and killed her. What homicide classification? It's first-degree murder. Remember, the reason why is going to state premeditated. He laid in wait for her. And then the last thing that I was sharing with you that you couldn't see, but now you see it, is the quiz. Do not forsake these. And then you start the activity. Intent to cause death with premeditation is considered what type of murder? Premeditation. There it is. Okay. So those are the things that I wanted to share with you tonight. And I will give you a key word. And the key word that I want to give you is homicide. That's it. So you present that and you get your points. So I'm going to say good night to you. To see you next week. And have a good Memorial Day holiday. All right. So I'm going to, let me click on that. I want to end the meeting. Okay.